Welcome to People Want to Know, a social media segment where we take your social media questions, and I have an expert here with me. You all know and love her. Her name is attorney Jessica Dominguez. Thank you so much for being here, attorney.
It's my pleasure to be here, Hito. Hashtag, I love my job. Hashtag, I love my son, JP.
Hashtag, she loves to hashtag, and I love you as well, mother.
No. Hashtag, you love me as well. Say it.
I have a very modern mother. I love you as well, mother.
He's learning.
All right, attorney, let's get right into this week's common question. A common question we always get is, how old does a U.S. citizen's son or daughter have to be to petition their parent?
Under immigration laws, they have to be 21 years or older.
So does that mean that every parent that has a son or daughter that's over 21 years old can qualify for legal permanent residence?
It's an excellent question, and the answer is not quite. Other issues of admissibility must be taken into consideration. For example, the majority of people who send these questions to us are people who have resided in the United States for over a year without a legal status. Based on that, they would have to pay a 10-year bar, a 10-year punishment before they could actually qualify to get legal permanent residency, unless they have two exceptions. One of them, if they came into the country with admission or with a visa, they wouldn't have to pay the 10-year bar. They could qualify for legal permanent residency here in the United States, or if they have the protection of 245I. 245I, it's a law that already expired back on April 30th of 2001. We already have a video that people can watch in case they want to know about 245I. But if they don't meet those two exceptions, if they apply, they're going to get an appointment to go outside of the country, to their country of origin, and at that point, by leaving the country, they would have to pay the 10-year bar.
Great info. So not everyone qualifies, correct?
Correct. And not many parents qualify for a waiver either. For example...
So what should they do if they don't have someone to help them qualify?
Well, first and foremost, the parents that in the situation that I just mentioned to you, if they were to apply, in order to qualify for a waiver for the 10-year bar, they have to have the following qualifying relatives. They have to have either a spouse or a parent who is a legal permanent resident or a U.S. citizen that can show that they would suffer extreme hardship if the waiver is not granted. If they don't have those qualifying relatives, if they don't qualify for the waiver, the best advice that I can give them is wait for a change in law, wait for comprehensive immigration reform here in the United States before you apply for a benefit that may result in negative circumstances instead of helping you better your situation.
Okay, so what if the parent is not in the U.S. and they want to petition their parent?
That's an excellent question. For those people that are naturalized, for example, here in the United States, and they have parents who have never been to the U.S. and who do not have any other issues of inadmissibility, they can start by filing a consular process, and they will be reunited with their future legal permanent resident parents in less than 2 years.
So, attorney, are there any other exceptions?
Another one that I can think of is parole in place, which is a benefit that's given to those parents of those sons or daughters who have either served in the Army in the past, are serving now, or are enlisted in the reserves. If you want to know more about parole in place, watch the video that we already have online to give you more information.
Thank you, attorney. Thank you so much for joining us.
It was my pleasure.
Thank you all for watching. People Want to Know. Make sure to subscribe to this YouTube channel, JessicaDominguezTV, and we'll see you next time with another social media question. Thank you.
Wait. Don't go anywhere.
Please subscribe to the left.
And watch our videos below.